I'm the Executive Director of the Levin Center. On behalf of the Levin Center and Slipper, we want to thank you for participating in today's symposium. And we're delighted to have Angelo Ancheta as our keynote speaker. Mr. Ancheta is a member of the California Citizens Redistricting Commission, so we are excited to hear about his perspective on how that process has gone. He brings a unique perspective as both a scholar of civil rights, voting rights, constitutional law, and clinical education, as well as that of a longtime civil rights and religious institution. Just yesterday, the California Supreme Court ruled that the 6 state Senate maps drawn by the Commission will be used in this year's election, despite pending referendum to overturn them. So there's a lot of exciting developments happening right now. We very much look forward to Mr. Ancheta's talk. Thank you.
Thank you. Is this coming through? I'm on a wireless mic.
Yeah.
Great. Well, good afternoon, and thank you very much for inviting me to speak to you today. This is a great symposium. I think in my normal life, where I'm teaching and just an occasional writing in the voting rights area, mostly on language rights, I'd be attending a conference like this. I think you're here, or I'm here today to basically talk about my extracurricular activities on the commission. So I'd like to highlight some of those activities over the next few minutes. But I think it's important, and as I've been looking back on the commission work, we're still active on the commission, but we produced our final map back in August. It's been a few months sort of took a little bit of a break from a very, very hectic and very time-consuming process. You started reflecting on what you actually did and how important it is. And of course, all of us in the room know how important redistricting is. But when you are in a different setting, and I spent the holidays with my in-laws and got to visit a lot of our relatives down in Southern California, you realize that not everybody is as interested in redistricting as we are, right? My wife was very proud of my membership on the commission. Like I said, well, Angela's a redistricting commissioner. And she says this to all the relatives. And of course, they all seem very impressed by that. But there's also this very blank stare that's going, well, okay, that sounds great, but what does a redistricting commissioner do, or what does that commission actually do? And that's always a challenge, because when you think about all the technicalities we deal with, the software, all the criteria that we're involved in, it's not easy explaining. I sort of come down to a 1-minute version every now and then when I say, well, as you might know, the legislature and Congress are elected from districts. People live in different districts, and they vote for people to get elected to office. And every 10 years, because of the census, we have to redo the lines. And we're in charge of actually doing that, what the commission actually works on. And that's a brand new thing. And I talk a little bit about the time we spent doing input, doing public hearings, gathering testimony, putting drafts together. And as I said, it took a lot of time, did a lot of traveling, went to a lot of places across the state, and we produced the maps back in August. And so on the commission, we're dealing with some lawsuits. We've won all of them so far. And we're doing a little bit of work just to figure out what we did right and what we did wrong. So hopefully we'll wrap up our work pretty soon, but it's a 10-year commitment, so I'm still going to keep doing it. So that's the 1-minute version, right? And that usually removes the blank stare, but folks still don't really know exactly what you do. And I think what I want to do today is to sort of give you a 15-minute version of the same story. Most folks in this room are very fluid in the process of redistricting. Some of you may have been studying our commission very thoroughly. It's interesting being under the microscope as an academic or policymaker. And, this is a very open and transparent process with a lot of public scrutiny. So it's very different being on that side of the policymaking process. But I think it was an extraordinary one for all of us who've been on the commission. It continues to be so. As you know, Proposition 11 was passed in 2008. Proposition 20, which was passed 2 years later, marked a major shift in the political alignment of who does redistricting in California. Shift from the legislature to an independent commission in charge and have produced maps to look at the state assembly, the state senate, the state board of equalization, the congressional delegation, the House of Representatives. And as we know, a big change in the power structure. Who draws the lines in California? And to the extent that California, through this initiative process, often good or bad, leads the nation in some novel policy making, I think it's an important development. I think it's certainly worth a study. I've had to live it for the past year or so. And I think it's worth talking about how all that came about and what resulted, how the process resulted in a set of, I think, a very good match. Now, as some of you may know, there was a very extensive selection process. It took over a year for all the commissioners to be picked. Over 30,000 people filed initial applications to be on the commission. There was a supplemental application, only about 4,500 people submitted applications, but it was a lengthy set of essays and financial disclosures, any possible relationships with the legislature, the lobbyists, background checks that were done. And the Bureau of State Audits, which was in charge of actually narrowing the pool, went from over 4,500 applications down to 120. So you can imagine that was a very hard process for them, but one that really winnowed down and got really good, very well qualified people together. Even with that 120, there were sets of interviews. We all had to go in and talk about about an hour and a half during the summer. They got it down from 120 down to 60. After it was down to 60, the legislative leaders had basically a veto vote, and they were able to narrow it down from 60 down to 36. And once it got to the 36, we were broken up into pools of Democrats, Republicans, and those affiliated with neither party, and there was a lottery system. Okay? And it's all the stuff you might see on television with ping pong balls and wire baskets spinning around, and you pick, at that point, the first 8 commissioners. And then after that, 8 commissioners will pick the remaining 6. So you ended up with 14 people at the end of that process who were, in theory, and I think in practice actually, were supposed to represent a good cross-section of California, geographically, racially, ethnically, gender balance as well. Now, I have to say, I wasn't even picked in the first 14. Okay, I didn't get picked I was not lucky. I didn't get picked, my ping pong ball number didn't come up. If you look at the demographic mix for that particular group of 8, I was not going to add to the diversity of the pool. Okay, an Asian American Democrat from San Francisco was already in that pool. You're not going to get a second one. Highly unlikely. And I understood that. You're trying to diversify the panel across many dimensions, so that was a mistake. But one of the commissioners stepped down in January. And despite my sort of not so great demographic set of characteristics, they decided to pick me. So I became the replacement commissioner in February of last year. So the process itself took over a year, and if you look at the actual timeline, 1 year to pick the commissioners, 7.5 months from January till August 15th was the time to actually draw the lines. Okay, so you can imagine that was a very thorough process, a thorough vetting process, and we have a great team of people who are on the commission. Attorneys, urban planners, engineers, a lot of professional folks, very well educated, very talented people, all work tremendously well in group settings, and we're very mission driven in trying to do our work. So there's no question for us that this is a really good group of people. And I think the process led to that. But if you think about how much work we have to do to redistrict in the state of California for its legislative boundaries and its congressional boundaries, 7.5 months is a pretty short amount of time. We had to pull together a staff. We had to find office space. We had to get consultants. We had to get attorneys. We had to deal with the contracting process, which in Sacramento is not a very efficient process. We had to put all of that together in the first 3 months. And we did it. We were able to do it. We had a great team of consultants. Arn McDonald was here with us. They headed that team. We did consulting team. A great set of attorneys as well. And we set about to have what is a very ambitious process. There were a lot of expectations that came out of Proposition 11 and Prop 20, that the process would be more open, more transparent, that you could remove as much as possible the politics from the process. You can't eliminate it entirely, but try to get partisanship, and certainly try to remove incumbency protection, and those sorts of influences, and all the horse trading that might occur with the legislatively based redistricting process. Try to get that out of the process as much as you could. We were very ambitious. We actually set up a process where we were initially trying to get close to 50 hearings done in that period, produced 2 draft maps before August 15th. We didn't quite get all the way there. We ran out of time in some instances. But we did over 30 hearings. We received over 20,000 comments, whether individual maps or districts or emails and faxes and postal mail. Hundreds of people often came to our hearings. So it was a very extensive and I think a very effective process to try to at least get some segment of the population of California who's interested in redistricting to come out and actually do it. So I think it was a very good process. It could have been done better, certainly. But I think we did pretty well given the time constraints. Now, if you think about what you have to do to redistricting, some of you obviously have done redistricting yourselves. You know it is a time-consuming process. You can't just sort of slap it all together. It's not all done by computer. You have to look at all the things you've got to put together, whether it's public testimony, census data, demographic data. All those things come into play. And, of course, it is an inherently political process. A commission is an attempt to try to remove as much as possible legislative interest, direct legislative interest, but it is impossible to remove politics from the process. Individuals, groups, organizations, and the public have interests. They want to see certain districts, they want to see certain alignments. And if you think about the power structure in the legislature, who has power, who doesn't have power, who would like to get more power, you know that people will try to change the lines, obviously. And if you look at the structure of the commission, which is divided 5 Democrat, 5 Republican, 4 other nonpartisan or minor party affiliations, you know that that doesn't necessarily reflect the demographic mix of California. The party registration for Democrats is about 50% higher than the Republican representation in the electorate. So there's a little bit of an imbalance, and I'll say that, and I'm a Democratic member, so I'll note that, but our friends on the Democrat, on the Republican side certainly were expecting something different out of this election. That was reflected certainly in the process. Alignment. Democrats did not support property leverage, Republicans did. And that continued through the process, even though at this point, well, mentioned in a moment, it's the Republicans who are suing us, largely in state and federal court. So we had a very extensive process, a lot of hearings, a lot of testimony. We produced at least one draft map in mid-June. We sort of ran out of time trying to produce a second one, but we did a very open process to make sure that people could see what we were doing while we were doing it. We made a few, missteps every now and then. I think one lesson in particular we learned is that if you're going to put out a draft map in June, you better make sure you've done your Voting Rights Act and your racially polarized voting analysis before you release your draft. Because if you don't do that before you release your draft, and if you're not lucky enough to actually hit those lines where they're probably going to fall, you're going to get criticized. And we were criticized. But we had set certain deadlines, and we had a lot of testimony already, but we hadn't put together a complete data set. And I think that's something we had to learn from experience, but as we move forward, we address those concerns, and we revise those drafts as well. So I think there were imperfections in the process, and given the time constraint, I think we did the best that we could. Now, we ended up, I think, with a process that is no doubt, in my mind, far more open, far more transparent, far more accessible to the public than what we've seen in California prior. We had individuals running from all over this, coming in from all over the state, multiple languages, English, certainly, Spanish, Asian languages, Armenian, a number of European languages being spoken out here. We had 3 teams who were testifying, with folks in the 80s and 90s who were testifying. Some folks came hundreds of miles. They drove hundreds of miles to come work here. So it was amazingly encouraging what we saw. And as we were putting our maps together, we had a number of criteria. We had a one-person, one-vote rule, Voting Rights Act, contiguity requirements, geographic integrity requirements, compactness requirements, what's known as nesting, trying to put 2 assembly districts in the Senate district, as well as an important prohibition, and that is we were not allowed to look at incumbency. We were not allowed to look at candidacy. We were not supposed to look at party registration. Now, if you think about how redistricting is normally done, how could that possibly be? How can you take out all of those interests? Well, that's part, how the law was structured. We tried as much as possible to depoliticize, or at least remove those kinds of considerations. Is that the best way to go? That's something to think about. Now, as we put our maps together, we had to make a lot of hard choices. As you know, redistricting is essentially a zero-sum game. You can't just sort of next part of Arizona or pull apart Oregon and create a solution. You have to deal with what you're dealt with. And we had some tough choices to make. In a lot of the state, the testimony was consistent, led us to very clear solutions. But in many parts of the state, we had very difficult choices to make. We had to try to reconcile different points of view, 2 or 3 different ways of drawing maps, multiple communities, advocating for different interests. Probably no more tougher than in Southern California. We're looking at the core of Los Angeles, dealing in particular with minority populations, looking at what was a relative decline in the African American population in many parts of central LA. We looked at Latino and Asian populations, trying to reconcile different interests, hearing different kinds of testimony. And if any of you saw the hearings or maybe looked back at the transcripts and tapes, it became quite emotional. And the issue of race, which is an inherent part of redistricting, came really up to the fore during some of those meetings, and a lot of tears were shed trying to figure out what to do in LA. So if you think of redistricting as all about maps and just drawing lines on a computer screen, there's a lot more to it. So how people identify themselves, how people think about communities, how they think about power within the state, all those things come into play. It's not just the technical side to it. It was a great process trying to put it all together. I think all of us, for the most part, other than in the Section 5 counties, where we had to look at existing districts to make sure that there wasn't retrogression, all of us, I think, thought we could start from a blank slate. And I think that's what we did. We weren't looking at incumbency. I think all of us sort of knew where our own districts were and how the alignment of the state generally was. But other than those Section 5 counties, I think we really said, well, we don't have to stick to anybody's prior maps. Let's look at something new, and let's look at the testimony. Let's look at what people have to say, how communities define themselves, what do we think, based on our own experience, ought to be the best way to put lines together. And I think that was a very effective process. Now, we were successful. Our maps came down to a vote at the end of July, so we could produce them for an August 15th deadline. I think a lot of us were concerned going into it, well, can we get the votes? Given the voting structure of this commission, where you have to have a certain number of each subgroup voting in favor of a map, we thought, well, if we lose a couple of people, can we get a map out? Okay. And all this work, all these hundreds of hours that we spent listening to it, going through testimony, working on the maps, we lose that if we didn't get the vote. Fortunately, we did get a vote. On the state maps, we had a 13-to-1 vote, and on the congressional map, we had a 12-to-2 vote. So even though there are clear partisan, by structure, partisan divisions among the commissioners, it's clear that it was a bipartisan, a multi-partisan effort, and all of us felt that the mission was accomplished in those maps in mid-August. Now, our job's not done, and those of you who've been following the developments around the commission, you know that there have been some lawsuits. A couple of state lawsuits were filed in the state Supreme Court back in September. The court ultimately dismissed the petitions in both of those cases that challenged the Senate maps and the congressional maps on both state and federal grounds. Those were dismissed. There is a federal lawsuit that's still pending. That's focusing on congressional districts in Southern California primarily, looking at federal and Voting Rights Act claims. We have, at this point, a potential referendum that may be appearing on the ballot. The Senate map is being challenged via referendum. The votes are the signature count is still not in yet. So we'll know probably by the end of February whether there'll be a referendum appearing on the November ballot this year. But as was previously mentioned, the Supreme Court ruled yesterday that even if the referendum does qualify, and by law the maps have to be stayed pending the resolution of the vote, the court said, at least as an interim measure, we will use, or the state must use commission's maps. So in that sense, the commission's maps are still in place. And I think we're confident that regardless of whatever whatever form it happens to be, with litigation or a referendum process, that we'll see those maps are developed. And we're confident about that. Now, again, I have a 10-year term, so I'm going to be a commissioner at least until the next commission gets picked in 2020 or 2021. And there's still a lot of work we're doing. We're looking at what went wrong, what went right in the process. We're trying to evaluate ways of improving the process. There's no question that we looked at the timing and the calendaring of all of these activities. It was much too tight. The schedule we were dealt with was much too compressed. Not that we would have done the maps differently necessarily, but that we had to put in a lot of data gathering, a lot of work with a far too tight timeline. So I think we're all going to be recommending to the law chief at least give us the next commission more time to do that. It'd be great to have a higher budget. We only have a couple $1 million to do redistricting, and at this point, we're probably spending more on legal fees defending the maps than we're actually drawing the maps. But as you know, that's what the nature of the redistricting process. Somebody's going to sue, and somebody's going to have to pay some lawyers some money to defend the maps. So that's an issue. Is this system one that other places ought to adopt? Okay, that's one of the big questions we're looking at. This has been a grand experiment. I think it's been a successful one, but is this the kind of system you ought to adopt? Now, whether you can adopt one in the first place is a tough one. This was a product of direct democracy. A ballot initiative, a set of ballot initiatives put together. The legislature didn't initiate this process. And trying to get a legislature to change the process if they give up the power they might possess and put it in the hands of the commission is a daunting. So I don't know if you can do that in states that don't have ballot initiative procedures, but it's worth trying. In those states that do, if you put together an initiative to create a commission like our commission, I think you could. Do you want to do it the way California has done it? Well, that's a really good question. Is 14 the right number? Can you represent an entire state among 14 people? It's 14 people too many. Can you actually get work done? We got work done. We did a lot of very good work with that number. It was very effective, and it was, for the most part, consensus during that whole process. But that may not be the case in other states, so is that the right number? It's the party balance, the way you want to go. Obviously, if you have a minority party, you love to have the same number of seats as the majority party. Right? But if it's a majority party, maybe that's not the case. So that's a big structural question. How do you divide that up? How do you involve the legislature, if at all? The legislative leaders had essentially a veto over part of the pool. We don't know why they did, why they removed who they removed. Sort of like a peremptory challenge to who the jury pool. They could have told us why they did it. They didn't. And maybe you want to know. Maybe that's something you want to mandate. But in any case, the legislature did play some role. And some may want a larger role. Some may want a lesser role. That's something to think about. So there's a lot of different combinations, a lot of ways to go. One thing that I think we ought to be should be a special concern, particularly given the theme of this symposium, is a commission necessarily a good thing for racial and minority rights? Does a commission system work better in terms of voting rights enforcement, in terms of guaranteeing political empowerment for minority groups? And I think the answer is yes, but I don't think it's necessarily so, even though in this case with our commission, I think we did a very good job in terms of satisfying concerns that have been raised by many civil rights groups in the enactment of Proposition 11. Now, as some of you may remember, most of the major civil rights groups in California did not support Proposition 11 back in 2008. There were concerns about the composition of the panel, whether the commission would be representative of minority interest, whether the actual outcome reflect sufficient input by minority interests. And I think given how the law was written and what actually occurred in practice, those concerns were allayed. Okay, if you look at the actual membership of the commission, 11 out of the 14 members are people of color. Okay, all 5 of the Democratic members are either Latino or Asian American. So if you're just thinking of it from I'm using the term descriptive representation often in this circle, and if you think about descriptive representation, that's not bad. 11 out of 14, so that's pretty good. But that's not the same as substantive representation, right? So if you think about what the outcomes are, the policies that come out of the commission, will you necessarily get a good outcome? Well, again, I think we did a very good job. I think we complied fully with the Constitution, with Section 5, with Section 2, and I have no problem saying we did the right thing. So we can defend our maps against all challenges. But is that guaranteed by a commission? Commissions, after all, like legislatures, are majoritarian bodies. Okay, they're majoritarian bodies. And even though California is often labeled a majority-minority state, that isn't the case when you look at the electorate. Okay, it's not the same when you look at who votes in California. So to the extent that a commission might not lead you to the results that you'd like to see given minority interest, I think that is a very legitimate concern. We have the court system, of course, we have the Voting Rights Act to try to check those potential problems, but it isn't necessarily guaranteed. I think if you look at the process that we went through, all of the outreach and the input, the commission in and of itself was not sufficient to ensure that minority communities got or received the outreach that they needed to receive in order to participate in the process. The James Irvine Foundation poured in hundreds of thousands, I think well over $1 million, to local community and civil rights organizations to make sure that minority communities in the state received the right information, that they were able to participate in the process. And as we've seen earlier and heard earlier, there was very good participation. But that's not guaranteed if you don't have sufficient funding. And when a private foundation injects that much money, that would have been over half of our budget for all of our work in the initial stages, that tells you that a commission might not be enough. That you need at least partnerships or that you have to fund it at a higher level. So to make sure that minority interests are protected, I think you have to make sure that there is sufficient resources. So given all this is the question I was often asked in August and September after, again, having spent hundreds of hours working on commission work. The question I was typically asked is, well, given all that you've done, all the time you sacrificed, the time spent away from your family, and by the way, I owe my wife several months of time spent away. I was away for a long time. I'll probably spend the next 10 years trying to make it up to her, all that lost spring and summer. But given all of that, would you want to do it again? And of course the answer is yes, absolutely. I would always want to do this again. This has been an amazing experience. And as someone who has been or still continues to be an advocate on a lot of civil rights issues, I know how important it is to get involved in this. All of us in this room understand that. But is it worth the sacrifice? Again, absolutely. And when you think about who's on the commission, the great team you work with, Q2, nicknamed them the Women in Black particularly because how Karen dresses when she comes to our meetings. This is an extraordinary group of people, great staff, consultants, and really a joy to work with. Just a joy to work with in terms of the process. The chance to travel throughout the state, to hear people testify, to talk about their communities, to share their stories, that was unbelievable. I learned so much about the state. I lived in the state for most of my life. I didn't know that so many small towns in Northern California, learning about neighborhoods and different communities was absolutely fascinating to me. So would I do it again? I don't know if I'll do it in 2020, but I would certainly go through the process again and work and provide service to the state. So ultimately, I think a commission system works. I think in this case it worked. I think in the future it will work. We may see challenges to that system again. The last time it was Democrats, we might see Republicans challenging it this time. But regardless of how it works out politically, I think this grand experiment was a successful one. That what we did here in California can be a model for other states, for local communities, and that when the people actually do get an opportunity to engage in the political process, they will do so. Thousands of people came out, and I think that shows the strength of the state, and I'm very proud to serve on this commission. So thank you very much.
talkative today. It seems to me at the meta level that the maps reflect reasonably accurately reflect a shift in political party strengths in California. The Republican Party now being around 31%, the Democratic Party being around 41%, and Independents being around 21%. And so, if that is a reasonable criteria to judge the new lines, it seems you guys have been successful in accurately reflecting the overall state shift in party orientation. Would you agree with that?
Well, I think it's a very good question, and I think that's probably right in terms of how you look at the maps and how they might align with current partisan affiliations. Now, obviously, there are a number of Republicans who disagree with that. They think that they've been given short shrift and they've litigated and challenging it via referendum. So there's not necessarily full agreement on that statement. But one thing that is, of course, a very interesting thing about this process is we were prohibited from looking at all of these data. So we were not supposed to look at party registration. We were not supposed to look at incumbency. And we didn't. I didn't look at it. And when we put together some maps, I'm like, oh, I think I put Zoe Lofgren and Mike Condon in the same district. Is that works? What is the San Jose area? Well, that's interesting. But, you know, and that's not the only place we did it. We did it in a lot of places. And that was just a product of what we did. Right? So, you know, there have been a few people who are in the legislature and in Congress who have decided not to run again because they might be competing against relevant incumbents. So that's an interesting development. You can't change the demographics of the state that much through redistricting. Okay? You know, you can't create a Republican district in San Francisco. You're not going to create a Democratic district in southern Riverside County. You can't. It doesn't. You can't do it. You have even a wildly gerrymandered set of lines. You cannot really put together in a lot of parts of the state what could be considered competitive districts. We weren't required by law to produce competitive districts. Arizona, as an example, has that in their criteria. We did not have that. Even though I think a lot of voters thought that would be part of what we did, we were not supposed to do that. We didn't do that intentionally, and I don't think that was a consideration. Did we produce more competitive districts? I think we did in a lot of areas, but again, California is what it is in terms of its numbers and its demographics and its party affiliations, and that's still evolving. And as you said, I think the Republican party base is declining a bit. Maybe in 10 years we'll see decline states and non-major party voters being perhaps or likely outnumbering Republicans and maybe even rivaling the numbers of the Democrats. So I think that will be an interesting development. And again, the structure of the commission, given those changes, might not be in alignment with what the electorate will look like in 10 or 20 years.
You mentioned the commission relied a lot on testimony and comments from people and from groups around the state. I was curious to what extent you relied on sort of more comprehensive statistical data in drawing the districts. And I assume you looked at racial demographics around the state, but I wonder what other sorts of data you might have looked at, income, profession, housing, et cetera.
Yeah, that's a very good question. And also, we had to look at were there areas of potential Section 2 violations. We had to look at the racial data is there. It's part of the census data set. We certainly relied on the core census data to produce, or at least in part to produce lines, and you have to keep the populations equal across the districts. But could we have looked at additional empirical data, different social science data, in terms of how we looked at the communities of interest or how the neighborhoods are defined? I think we could have done more of that. I think partly because of a normative concern to make sure that we had a lot of good public testimony. We emphasized that. I think if we had more time, we might have been able to go through more data. I think we talked about this in the commission as well, because we were trying to figure, well, given what the public is saying, does that necessarily align with what actually the demographics might say? Because someone's perceptions of the community might differ significantly from the actual numbers that you can see in the census or the data. So that was a concern we had. But, and I hate to always say this, but we just didn't have all the time we wanted to do that. And I think that's why we're actually encouraging the legislative changes to actually push back a few of these deadlines to extend it out a little bit longer. Now, we don't have a binding effect on the next commission. With the constitutional provisions that are in existing statute or existing regulations, we can change a little bit. But for the most part, the law gives a lot of leeway to the commission. So if the next set of commissioners wants to really look heavily at data, I think they can do that. And again, I think that was a concern we had. And we just said we can look at what we've got. We've only got a few more weeks left. Let's just keep going.
So there were two big changes between the last round of redistricting and the commission round, and I wondered if you might speculate about the relative effect of them. One change, of course, is who did the redistricting. It was a move from the legislature to the commission. And the other, of course, is the formal listing of a set of criteria and their rank ordering. And I wonder, do you think a commission without that rank ordering would have done as well? Do you think a legislature, if given that rank ordering, be judicially enforceable, would do as well? That is, what's the relative contribution of these two changes to the changed outcomes?
Yeah,
and if I could just have one last piece of that, which is, of course, what constitutionalizing this has done is it has written into stone and made it quite hard to change either how the commission is picked or what the criteria should be. And so I wonder if you might speculate about that third piece as well.
Yeah, and you're absolutely right that both factors are critical. You know, try to do some regression analysis, figure out which is more important. I'll leave that to the PhDs in the room. But both, I think, had. I think all of the commissioners agreed that while it wasn't an easy job, it was easier to try to reconcile all these different interests by saying, well, we've got to comply with the Voting Rights Act. That's number two. Okay, we understand that you have a community of interest here, or that we might be splitting the neighborhood. We'd love to keep your city intact. It's wonderful. But if we don't do what we're going to do, we might violate the Voting Rights Act. So to the extent that different criteria, and again, if you're looking at this as a model, other states might want to do it differently. You can't get rid of the one person, one vote. If the VRA is not listed, the VRA still applies. So you can't get rid of those criteria. But when you're given a ranking and you have to choose, make some hard decisions. There's some easy ones, but there's also a lot of hard decisions. Having those rank criteria really helped a lot. I think we consistently turn to those criteria to try to figure out some of the problems we were trying to solve. Now, you know, if you started with one rather than the other, if the legislature had the same set of criteria, would they produce roughly the same types of maps? I don't know. Again, the prohibition on incumbency, I think, is a really big one. And would you ever see that kind of prohibition in the legislative system? I tend to doubt that, but you know, it's conceivable that you might see those parallels under a legislative system. So you're absolutely right. I think it's both. Yeah, we're locked in. Now, there's a constitutional amendment. We can change the law. Some of these provisions are statutory, but the core ones that we're talking about right now are, in essence, part of the California Constitution. So short of actually a new initiative or some constitutional convention, we're not going to see changes. I think they're good criteria. I think they're very workable. You know, other states might want to look at other things. Competitiveness is a really tough one to work with. I'm glad we didn't have to deal with that one. That's a really tough one. You have to consider it. You know, we were supposed to try to nest districts if we could. We nested a few. We combined a couple assembly districts into Senate districts. But for the most part, we just felt, well, we need to look at the other criteria. We might be splitting a city, or we might be violating the VRA if we nest. And if you look at the draft map, we nested a bunch. We got tired, frankly, in order putting that first draft together. We ran out of time at the very end. We started nesting a few districts. And that didn't work. We changed it when we came down to the final map. So I think the effects are cumulative, certainly. But yeah, I don't know. It's worth speculation. It's very, very important.
I have a question that follows up on what Nate said this morning about the commission going forward. And so the worry, I'm a commission fan, but the worry about commissions is always that partisans will eventually find some way to influence it at some point, whether it be an expert commission or whatever. And the sort of interesting thing about both your experience and the British Columbia citizens, actually, which was doing something different than you were, but is the first round, the partisans hadn't really figured out how to influence what was going on. That is, they hadn't mastered it yet. But
I think that's a very real concern. And we've had conversations about that over dinner. We're thinking, this was a really great experience. And it's never going to be like this ever again. Because, which is not to say, again, you can't take the politics. However you do this politics. And by design, you've got a certain number of partisans on the commission. And there are checks, we think are good checks, in terms of disclosures, financial contributions, affiliations. Can you come up with a partisan and sort of turn them into a nonpartisan over the course of 10 years? That's certainly possible. So I think that's, I don't know, what can you do about that? There have been some media reports in the last few weeks talking about whether the Democratic Party has conspired to try to fool the commission and put some folks into the testimony who weren't really who they said they were. I don't know if that's true or not, but we knew early on that a lot of the groups where did these groups come from? I've never heard of these groups. I'm not to say they were front groups, but obviously if you're trying to do this kind of process, you're going to try to say, I represent this coalition. Even though, by the way, I might be running for the office some point, but I represent or I'm with this community. So we figured that out pretty early, that not everybody was being quite upfront about who they were affiliated with. So to say that we were sort of hoodwinked by political parties is not accurate. But even if that did happen, so what? I mean, the suggestion was a good one, and it made sense given what we were trying to do in terms of problem solving. If that suggestion came from one source, that's fine. We'll take it because it could help us figure out how the puzzle pieces could be put together. But yeah, I think that's, if you're a Democrat or a Republican leader, you might be thinking about that. How do we get people on this commission? We've got 10 years to figure this one out. Get our people on the commission. And I don't know that you can completely insulate this process from that kind of basic infiltration, but just that from happening. But I think the Bureau of Audits, by the way, is composed mostly of accountants, but they do investigations, so they're pretty careful about it. They dug into people's backgrounds pretty thoroughly, so I trust that they can actually do a pretty good job there. There's no question that given the system and how it currently works, you either want to change it if you don't like what you're getting, or you work with it and try to gain it. So not to point fingers at anybody, but I suspect that's going to happen.
Personally, stabilizing the elections that we want is a heroic job, and we want them to impress the time and huge sacrifice. And I was skeptical coming in, the one question it relates to what you were just saying was how you evaluate opinion and interest arguments. Leaving aside, so much of it is going to be pretextual, but literally how you balance out the conflicting community interest arguments. I hope you write a book actually about your experience. I know that some other people, but it would be really wonderful to have someone on the inside and do it as soon as you can, right?
Not while we're in litigation.
Yeah, but this is a unique, it has lessons not just for the redistricting process, but for other kinds of institutions, both over central politics also.
Yeah, that's not.
But I've certainly been in situations where you contradict your arguments about communities of interest. Now you had to deal with 13 other colleagues, and so I'm interested in, if you can, give us a sense of how those kinds of arguments were dealt with by the commission, and how you mediated between conflicting arguments. Leaving aside the DRA and racial.
Yeah, and communities of interest is it's a slippery concept, and I think we've got at least one of our panel positions trying to give a little more flesh this afternoon. There's more specific language actually that came into being because of Prop 20, which I think was trying to define a community of interest. That was a very interesting phrase. It still is an interesting phrase, and a lot of my colleagues on the commission, I think, interpreted it more broadly than what the Constitution said. I was always pushing for this is local communities of interest, and here are the examples. There may be various ways to define it, and I think that's fine to do that. And I don't think we had to lock into a single, very fixed definition. This is a community, and this is not a community. But when you look at what at the testimony, look how the public looked at the term, look at how some of the commissioners were looking at the term at the time, very broad. You know, the San Gabriel Mountain community of interest spans hundreds of miles. The coastal community of interest, the Northern California community of interest. Those are common interests. I think that's not the same. Common interest or related interest is not the same as local community of interest as defined by the law. So there was some imprecision, I think, in trying to do it. And there was certainly conflicting testimony. And there's always going to be some level of conflict with any definition. Well, my community goes from this street to this street. And somebody says, no, it goes from that street to that street. And if you butt them up together, that's going to be a disservice to both. You've got to pick one or the other. Right? So here's where the Latino community is in Berryessa versus the Asian community. Where's the line? It's on Mayberry Street or it's on whatever. That's the level we often get to. And I happen to know San Jose. I work in the area. So that was probably the most slippery of the criteria we had to deal with. I personally pushed to make sure we had some good definitions for neighborhoods, and I pushed to say, well, we've got things like the Los Angeles neighborhood boundaries, and they actually define their boundaries. So let's use those maps. That'll be helpful. Same with things like San Francisco and San Jose. Let's try to rely on some additional data, and I think that was helpful in some of those definitions. Community of interest was very slippery for us. And I think there could be more precision, but I'm not going to second guess how the other commissions were sort of looking at it. And I think ultimately we got to the same place once it came down to drawing the final maps. But it is not easy. And again, could you rely more on more empirical data rather than just purely on testimony? Sure. But this commission went out of its way to get public testimony. Okay? If you think about what we set out to do in the very beginning, I was skeptical when I first wrote this plan, so I came on a little bit late in the process. And I heard people talking about 50, 60 hearings. Are you nuts? 50, 60 hearings, that's a lot. But I sort of bought into that idea eventually. We better do a lot. I'm not going to, no one's going to say, or if I say, well, maybe we should just do 20. I'm going to get shot down. Right? That's not going to command enough votes to say, let's do this. Or let's just do one really good revenue. It wasn't going to go that direction, at least, given where we were going and what people wanted to do. So when you're trying it for the first time, and it's a really radically different kind of system, and you're trying to open it up, you may go a little bit overboard. And I think that's okay. I think I was fine in the system. And if it was more democratic, all the better. But ultimately, still got to run the map. So that's what's always tough.
Actually, Nate just totally stole my question. But I have a follow-up along the same lines that I wonder if I could ask you about. So on community of interest, I'm really fascinated with how you approach that. And I guess what you said was really interesting, but I wonder about one specific question, which is one way of defining community of interest would be to say, we're going to look at demographic data, and we're going to identify some group that we think that there's underlying similarity. And we don't necessarily care about what their political preferences are. They may actually vote for different types of candidates, but they're similar in some sort of important way. And we'll define that as a community, and that's what we'll start. A different way is to look at political preference and say, these people seem to prefer the same types of candidates, and there might be demographic difference among them, right? But we see them as a political community. And I'm wondering which you favor, what you learned about that process, what's more important.
Yeah, that's a really good, and I might want to think about it a little bit more as I'm talking. But there is this sort of explicit prohibition against looking at incumbency and party data, and I suspect if we started getting into that discussion, there would be concern. Even though it makes a lot of sense to think about, well, how does this collective, lack of a better, actually sort of express its preferences? And that might be along party lines. It might be along, say, a line based on race or ethnicity. It might be something. Pick your criterion. It might be something different. And I think that's worth looking at. And again, I think with the luxury of time, I think we might, with the caveat that we might not have looked at partisan data specifically. I think it would have been taboo for us to look at that at that point. But would we have done more analysis? Would it have been helpful to have a demographer on staff to do that? We had a lot of data in the statewide database, and our team was very, very thorough in terms of putting all the data sets together, but there's no shortage of other kinds of data that would fall outside the census. So could we look at other things? How do you vet some of that information? What if it conflicts with the testimony? Again, in a lot of ways, we were trying as much as possible to have a people's process. And I think that normative interest in opening it up to the public really dominated a lot of our considerations, good or bad. So I think the question is really one that, I think in the future it ought to be dealt with more squarely. And I think as we're sort of going through this evaluation process right now, it's like I've been raging a little bit. I think we're going to continue to rage because we have the luxury of saying, well, 10 years from now, maybe it's better to have this kind of data available to the commission. And that's how, once they sort of figure out what they're going to do, that's how they maybe ought to do it.